Okay, Chair Ocen, we are ready whenever you would like to begin. And I'm not sure if she can hear us. Chair Ocen, do you hear us?
Yes, I can hear you. I'm ready to start.
Excellent. Whenever you are ready.
Okay. Good morning and welcome to today's virtual conference hosted by the Los Angeles County Sheriff's Civilian Oversight Commission. This conference focuses on the important topic of corrective action in Los Angeles County. This morning, we will discuss how operations within LA County are monitored, the process of evaluating incidents and implementing corrective action, and how these measures of accountability apply to the LA County Sheriff's Department. My hope is that at the end of the discussion, we'll have a better understanding of corrective action and steps toward improving its effectiveness. We have an immense task here in LA County with a department the size of the Sheriff's Department, a county as complex and dynamic as Los Angeles, and a state as complicated legally as California. So we appreciate the diverse panel of speakers that we have lined up today to share their insights and expertise on corrective action as it relates to the Sheriff's Department. Today, you'll hear from Destiny Castro, the Inspector General for the county's Chief Executive Office Risk Management Branch, Sergeant Melynie Rivers from the LA County Sheriff's Department Risk Management Bureau, Los Angeles County Inspector General Max Huntsman, Loyola Law Professor Eric Miller, and our very own JP Harris will be your monitor. He is one of the inaugural members of the Civilian Oversight Commission and a former Los Angeles County Sheriff's Department lieutenant. Commissioner Harris, thank you for being with us today. I hope that you all have a robust and fruitful discussion. Commissioner Harris.
Well, thank you very much, Commissioner Ocen, and I'm really happy to be here today. I want to welcome everyone to today's discussion on corrective action, learning from our mistakes. Every department within Los Angeles County is overseen by the Chief Executive Office's Risk Management Branch to evaluate risk, minimize or eliminate loss, among other activities. We'll look at how LA County, specifically the Sheriff's Department, conducts this work, what impact it has, and explore how it can be improved. The county considers and evaluates issues that have occurred to avoid the risk of similar incidents of lawsuits, legal violations, or even death from happening again. It is important that departments identify these issues, take corrective action, and be accountable to reduce the likelihood of future incidents. Without going any further, I'd like to introduce the Chief Executive from the Chief Executive Office, Risk Management Branch, Inspector General Destiny Castro. Destiny, please go ahead.
Good morning, everyone. My name is Destiny Castro. I'm with the CEO's branch. I'm the Risk Management Inspector General for LA County. And we are going to talk about the Summary Corrective Action Plan and Corrective Action Plan process countywide. This deals with approximately 36 departments. We're going to go into the overview of what exactly is the Corrective Action Plan and what the process is. So for the agenda today, we're going to go into a Corrective Action Plan, which is a CAP, the policy, the definition of a CAP, the definition of a Summary Corrective Action Plan, which is a SCAP, the confidentiality of these documents, the CAP and SCAP process, the claims board, the cluster meeting, and what the Board of Supervisors finally do with the corrective action plan once it's finalized. Next slide, please. So the corrective action plan process has been around since about 1980s. Gloria Melynie first instituted the corrective action plan process. It wasn't very formal in the beginning, and it started with the Department of Health Services. When something wrong or terrible occurred, we wanted to mitigate those occurrences. And so Gloria Melynie said that we should have a corrective action plan process. So basically, we look at when something goes wrong, how do we fix it? What do we look at? And that started, as I said, in about several years ago, about 20 years ago. Since then, the board has revised the policy, and in 2016, we made significant changes to the policy. Some of those changes, and the most significant, were the deadlines for departments. So corrective action plans could take several months up to a year to draft for the department. And this would slow down sometimes lawsuits and settlements. And so we created a new system where all corrective action plans go through mine section, and they have to have a draft due within 30 days, and the final corrective action plan would be within 90 days. And that was the most significant change that we had, that they had time limits, and if they were not completed within 90 days, that would be reported to the board. Next slide, please. So when is a cap and SCAP mandatory? So per the policy, the Board of Supervisors ordered the creation of a program to develop, implement, and manage specific corrective action plans and summary corrective action plans. This is for all tort liability or like tort liability, medical malpractice claims, slips and falls, car accidents, anything over $100,000. So what that means is any kind of lawsuit that's a tort, like a slip and fall, a car accident, law enforcement, medical malpractice over 100,000 needs a corrective action plan. This is a formal document that's submitted to my office that we work with the department on, and then we're going to go through the whole process of who gets to see that, how it gets processed, who gets to see what, and who gets involved in creating those, and then what's the board's role in that. Next slide, please. Okay. So a corrective action plan. What is a corrective action plan process? The corrective action plan is where one or more corrective actions, steps are identified and placed into a formal document in order to correct a problem or incident that has occurred. So basically, you're using a root cause analysis. You're identifying a problem. Normally in a lawsuit, we see as something has occurred. Let's say a car accident. Why did that car accident occur? We're going to do a problem-seeking analysis, and then we're going to find a solution of why this occurred. Did they need more driver training? Were they speeding? Those kinds of things need to be looked at. And that is what a CAP is, and it's an actual formal document. Next slide, please. So what is a SCAP? You may hear the SCAP terminology a lot. A summary corrective action plan is a public document. So we're going to go into the next slide, please. Confidentiality. So what's the difference between a CAP and a SCAP? CAPs are confidential. They normally have personnel information in them and more details. And so the SCAP was created so the public would have a document to see what exactly the departments are fixing or correcting that wouldn't have perhaps like personnel information. So CAPs aren't confidential, SCAPs are not, except in some employment cases. So therefore, SCAPs are public documents. Everyone in the public can see these, and they are listed on the board's website under the statement of proceedings. Anytime there's a lawsuit that is a tort or tort-like liability, there is a summary corrective action plan attached to the board's agenda. Next slide, please. The review of a SCAP's CAP. What is RMIG looking for in a CAP and SCAP? So what am I looking for in my office? So what we're looking for is we're ensuring that appropriate corrective actions have been taken and are realistic. They're obtainable, they correct the problem. Some of this includes discipline, training, system-wide corrective actions, and just some of the items that we look at. What are obtainable goals? So is there an undue burden to the department? Do they have the budget? Do they have the financing? Do they have the staffing? Is this something that we're just going to say, oh, it's a policy violation and rewrite the policy? Is anyone going to look at the policy? So we need to look at it and say, are we actually reviewing the policy and implementing the policy? How are you disseminating the policy? So those are things that my office is going to look at. So we look at the lawsuit, we look at the documents, we look at the review, we ask the department's questions. Then we look at the corrective action plan itself and the summary corrective action plan. Many times we send it back saying, you know, this is a great first draft, but we want to see more information. We want to see, how are you disseminating the policy? It's great that you're changing the policy, but how are you going to implement it? Training. Oh, we're going to do training. Well, who's going to be trained? Is it supervisors? Is it everyone? Is it a specific person task? What is it that caused the problem, and is that person actually being trained? And so we look at the generic, we look at the system-wide, we also look at the personnel and making sure if this particular individual needed to be retrained, did that particular individual get trained? So those are some of the things that we're looking at. to make sure that the corrective action plan is effective and it's not just words on a piece of paper, that is actually going to be effective. Next slide, please. So the CAP-SCAP process. So what happens to the CAP and SCAP once it's been approved by my office? Once it's approved, I sign the SCAP, it goes back to the department who gives it to county council, and then they will schedule a claims board meeting and get it to the next process step. Next slide, please. So what is the claims board? The claims board involves all settlements between 20 and 100,000 the claims board approves. There are 3 people that sit on that: auditor, controller, county council, and the CEO's office. So they will take a claim between 20 and 100,000 and they will approve it. So what happens to the cases over 100,000? They look at those as well, but they gave a recommendation to the board. So they'll look at all the cases and lawsuits with the corrective action plans attached and say yes or no, it can move forward. Once it's forward, then it goes to the next step. Next slide, please. So cluster meetings, what's a cluster meeting? So if a claim's over 100,000, a claim and a CAP go to the appropriate cluster meeting. This could be the public safety cluster. This could be the family cluster. This could be the health cluster. There are different clusters that deal with different lawsuits because we have specialized board deputies that deal with each of those certain clusters. So in those meetings, we have the department, county council, my office, and the inspector general, and we deal with the corrective actions. We go with the case, we go look at the settlement, and then we work with the board deputies and we talk about the corrective actions. The departments take the lead on that, and there's a back and forth scenario. Many times the board deputies will say, well, you know what, we think you should do this a little different, or we would like to see more information. Then it's sent back to my office. I work with the departments, and we will fix or add more information to the corrective action plan to deem it appropriate before it goes to the next step. Next slide, please. When does the CAP go to the Board of Supervisors? So for all claims and settlements over 100,000, the claims board refers the settlement, then it goes to the cluster, and then it goes to the board for final action. The board is the one that will approve the final settlement as well as the corrective action plan. So if the board gets to them and the board deputies didn't like the corrective action plan, or the claims board didn't really recommend that it should be settled or with the corrective action, we could settle the case and not approve the corrective action plan. We can settle the case and approve the corrective action plan, or the board can send back the corrective action plan. This happens sometimes, and then what will happen is we will get it back to the department. I'll work with the department, and we'll take the board's recommendations and modify the corrective action plan so it addresses their needs and concerns. Once that's done, it goes back to the board, and then it's officially approved. And then the corrective action plan in the lawsuit will be approved and finalized. And that is the process of a corrective action plan, from where we started, where they come from, where's the policy, why we put them in for over 100,000. Then it goes to my office, claims board, the clusters, and then the Board of Supervisors. Next slide. So this talks a little bit about what we changed in 2016. This goes into the 90-day requirement. So you can see that in fiscal year 2019-20, we had a total of 63 corrective action plans that my office approved. So that was within 90 days, they had to complete them. And you can see that they all completed it within the 90-day. None were outside of the 90-day deadline. You can also see that Sheriff had 28 corrective action plans and Health Services had 10. And then you can see that all the other departments had 1 or 2. And that you can see a good overview of how many corrective action plans we get countywide, and that we deal with all 36, approximately all 36 departments. Next slide, please. And this is the board approved CAPs and SCAPs. So the 90-day requirement is for RMIG, my section. Now this is how many approved through the board. So through 2019 through 2020, we board approved 48 corrective action plans. And so the numbers are different because mine's from 90 days and this is for the whole year of what the board approves. Sometimes the board approves more, less, but this is about 48 to 62 is about an average of how many corrective action plans the boards approve each year. As you can see, the 35% is the Sheriff's Department, and the next biggest one would be Health Services, which is what the 90-day ones we just showed before shows that they're the two highest departments with the most activity is claims and lawsuits, and there's where all the corrective actions come from. Next slide. And so there you go. That's just a quick overview of the corrective action plan process in LA County. And my contact information is at rmig@ceo.lacounty.gov. That's the email for me and my staff. And then we also have our website down below. If you click on there, you can get into our sample cap and SCAPs. You can see all of the memos, starting with the beginning with the board mandated, the corrective action plans, all to the last 2016, where we modified it to get those 30 and 90-day business deadlines. So there you go. I hope everyone has a great day. Thank you.
Thank you, Ms. Castro. We really appreciate that. It was very, very interesting. Next, we'd like to hear from Sergeant Melynie Rivers from the LA County Sheriff's Department's Risk Management Bureau. Welcome, Sergeant Rivers.
Thank you. Thank you for having me here today. And we also have on the line Captain Albert Maldonado from Risk Management is on the line as an attendee. First of all, I would like to welcome everyone to the Los Angeles County Sheriff Department Corrective Action presentation. Today, we will be discussing the corrective action and the summary corrective action development and process, as well as root cause determination. Next slide, please. The corrective action plan is Sheriff's Department policy. Pursuant to protocols established by the Los Angeles County Board of Supervisors, when there's a lawsuit liability settlement over the judgment that exceeds $100,000, a cap and a SCAP must be developed and produced by the Sheriff Department. Now, a corrective action plan, as Destiny Castro explained, is a formal document. It consists of the summary of the event or incident, root causes are identified, and the Sheriff Department addressed the corrective action steps. Now, a summary corrective action actually mirrors a corrective action plan, but the confidential information is removed because the summary corrective action plan is a public record. Now, once the summary corrective action is approved, it is then published on the Board of Supervisors website located on the board agenda under the case name as an attachment. And by posting the summary corrective action plan, it ensures that the incident or activities are transparent. Next slide, please. The corrective action plan process, review, and approval is also a Sheriff Department policy. Risk Management Bureau Corrective Action Plan Unit sends the request of a CAP/SCAP to the concerned division chief. The concerned division chief will review and ensure a corrective action plans are developed. The corrective action plans are authored by the unit commander or his or her designee. The premise behind the process is that those units closest to the issue at hand can best rectify any remedial actions that are needed. Once the CAP/SCAP is completed, the concerned division chief approves the documents for processing. The division chief will then send it back to Risk Management CAP unit. It will then go through a series of review and approval through Risk Management, and then sent to the Professional Standard Division chief for a review as well as approval. Once it's approved by Professional Standards Division, it is then sent back down to the Corrective Action Plan unit, and we will send it to the Risk Management Inspector General, Destiny Castro, the Chief Executive Office, for review and approval. We'll get feedback from Destiny Castro, and if our corrective action is then approved, we will then send the document to County Council. Next slide, please. Now, the benefits and importance of a corrective action plan and a summary corrective action plans are 4 words to keep in mind. Prevent reoccurrence. Provide preventative measures and recommendations. And all of our corrective action plans are between 3 and 4 or even more recommendations. And those recommendations can include training, discipline, department-wide policy updates and changes. The next key word I would like you to pay attention to is satisfy. Satisfy legal and sheriff department policy requirements in claims and litigations over $100,000. And lastly, to build department awareness, identify lessons learned, and communicate best practices with our departmental personnel. Next slide, please. Root cause determination. How do we determine the root cause in an incident or an event that occurred? Well, what we do for the sheriff department is we ask the question, why? Why did this happen? Where did it happen? When did it happen? And how did it happen? Those questions are asked until we are able to identify the issues within that incident or event that occurred. Next slide, please. Root cause for law enforcement issues, shooting force. I think you skipped a slide, but I will continue, that's fine. It's okay, I'll continue. Anyways, root causes for the sheriff department is department employees usually react to actions presented by non-department persons. So you ask the question, why does the department always identified as the first root cause when the non-department person is more responsible for the cause of the incident? The answer to that question is a corrective action plan process is designed to evaluate and improve the department's actions. Accountability, we're accountable for our actions. The department is not blaming the non-department person, but identifying how we can change and we can make maneuver through the issues identified in a corrective action plan. Next slide, please. A better way to identify a department root cause is to identify any and all department issues related to that incident. The root cause in a CAP is not always the cause of the incident. The root cause is an issue that the department can address to or improve. Next slide, please. Here's a case study of a vehicle collision. Undesirable event. Department vehicle rear ends a stopped vehicle in front of them. What's the hazard? Inattention. Immediate cause. Driver looking at the NDC. But what are the root causes in this summary? And this is what the department identifies and looks for. The driver was following too closely. Failure to stop. Distracted driver. Now, what are the corrective action steps that the sheriff department will take? 1, the driver found at fault for the collision, unsafe speed. The driver given departmental administrative driving points. The driver found in violation in policy. So the driver will receive 3 days suspension for the violation of department policy of operation of a vehicle. But lastly, training and prevention. The driver sent to EVOC. EVOC stands for Emergency Vehicle Operations Center. That's a place where we'll send our personnel for training and updates on driver trainings and policy when it comes to emergency driving, as well as station evaluation for the primary cause for the employees' traffic collisions over the last 3 years. STAR driving program is implemented at that station to address most frequent issues identified in employees' collision. Next slide, please. Claims Board and Public Safety Cluster Agenda Review Meetings is also a sheriff department policy. A concerned division executive is responsible for attending these meetings to present and justify the actions in the corrective action plan. The corrective action plan will then be forwarded to the Los Angeles County Board of Supervisors for final approval. Once the approval is final, it is then posted on the Board of Supervisors website under Board Agenda. You can find it under the case name, and the summary corrective action plan would be as an attachment to that case name. Next slide, please. Here is a graph of 2016 and 2020 number of settlements that we authored here at Sheriff Department for corrective action plans. From 2016 to 2020, approximately 259 corrective action plans were developed and written. And for 2021, we are at this time at 26 corrective action plans that we've authored and submitted to RMIG. Next slide, please. 2020 and 2020 settlement costs. This chart is showing you by category. Traffic collisions, 41%, are the most frequent lawsuit liabilities we actually see here, the Sheriff Department. Next would be use of force. Negligence is 9%, shooting 7%, wrongful convictions 2%. So here's just some sort of overview of our statistics and data we have collected for 2020 that will show you that traffic collisions are our primary corrective action plans that we see most frequently. Next slide, please. Again, thank you so much for having me here today as a representative of the Sheriff Department. My name again is Melynie, Sergeant Melynie Rivers, and Deputy Shanice Winfrey is also a part of the Corrective Action Plan unit here. Again, thank you for your support and thank you for having me here. Questions?
We'll be coming back to a Q&A section once we have all the presenters have a chance to make their presentation. So thank you for that.
Thank you so
much. Trust me, we'll probably get back to you with some questions. So hang on, we'll get there. And again, thank you. Now we'd like to hear from LA County Inspector General, Mr. Max Huntsman. Max, please go ahead. Max, unfortunately, you're muted. You're muted.
Thank you. Sorry about that.
Okay, no problem.
I just want to start by saying that Inspector General Castro and Sergeant Rivers do an excellent job, as do the people they work with. And what I'm about to say is not a criticism of them in any way, shape, or form. But the premise that somehow government learns from its mistakes and as a result does a better job in the future applies only to very minor matters. As you heard in the corrective action plan, the template used is one of a traffic accident. Yes, if a deputy drives a little too fast and hits somebody, that's something that a corrective action plan is effective at correcting. But when it comes to matters that are deeper, more systemic, more problematic, the system does not work at all. The quote I have here from Frederick Douglass was addressed to the problem of slavery, but it applies to any situation in which a government mistreats its citizens and operates outside the law. Of course, slavery was legal in one sense, but when the founding fathers created the nation and wrote down their principles, they wrote that all men were created equal. They didn't mean it, but they were violating the law from day one. And Frederick Douglass would not have been impressed had they said they had a corrective action plan. Government does learn from its mistakes, but not in the way that we're talking here. Bureaucracy learns to protect itself, and politicians spin facts in order to benefit themselves. Recent cases prove that. There's an example recently where LASD was caught illegally rehiring a deputy gang member who did political favors for the sheriff. The corrective action plan was to make sure that the public never found out again about, and they did that by obstructing oversight and forming a secret police unit to target any critics of the sheriff. LASD was also, again, in a legal case, caught illegally muzzling the coroner about shooting by police, and was the court in that case referred to what the sheriff's department did as shocking the conscience. The corrective action plan was that detectives, not the people being investigated, but the detectives took the fifth at the upcoming inquest. so that the coroner would have nothing to tell the public. And when I use the term corrective action plan here, I'm not referring to the formal documents that we've just heard about. Those are confidential, and I can't tell you anything about them. I'm referring to the conduct of the Sheriff's Department after those adverse court rulings. Right now, we see it happening in the front page of the paper. The sheriff is aggressively fighting against Vanessa Bryant, who is attempting to get him to state under oath whether or not he ordered the destruction of evidence by telling deputies to delete pictures of a crash scene when he could have collected the phones and examined them forensically. Two of his close subordinates have testified that they couldn't remember the order he gave. The corrective action plan seems to have been to promote them. They both got promoted. And some other people got demoted or transferred, apparently punitively, who did remember what the sheriff said. So if there's a confidential corrective plan, action plan built around that case when it's over, do we think that the lawyers involved in fighting it so aggressively are going to do a better job right after their loss, if that's how it goes? I think it's unlikely. But even what I described are small corrections. When set next to traffic accidents, obviously they're much more important, but they're still small. They're not the elephant in the room. It is possible that you can count on government to do the right thing when it really matters. So, let's talk about that. Deputy gangs. Tell us about the corrective action plans for those. The county has paid out $55 million, or so the last count that was done had it at, in deputy gang cases. And how many corrective plans do we have that get rid of deputy gangs? They're confidential, so we can't say it. But the last time the sheriff addressed this publicly, before he stopped going to the COC in response to subpoenas, was to say that the number of people fired under his supposed policy against deputy gangs was 0. So that corrective action plan has not had a result. That's after a huge lawsuit in which Guadalupe Lopez sued the county over sexual assault related to banditos. Lawsuit. $1.5 million settlement. So clearly there must have been a corrective action plan. The then Sheriff John Scott announced publicly that he would investigate the banditos and the results would be made public. That wasn't true. They were never investigated and no results were ever made public. Sheriff McDonald assured the public that he'd investigate deputy gangs, but didn't. When Villanueva came in, he said he would also resolve the problem. But when he went to investigate the Kennedy Hall case in which the banditos were alleged to have assaulted a group of fellow deputies, instead of actually investigating it, they maintained a code of silence and allowed a dozen-some deputies to not give statements so that those people were insulated from prosecution and the banditos members were never prosecuted. So as a result, the legislature has passed a law. The law goes into effect January 1st. It allows for outside investigation, not a corrective action plan put in place by lawyers for the people who have just defended, the people who have been found to have committed misconduct of some sort, but rather an investigation done externally. It empowers myself and the Attorney General to conduct those investigations. And then it also provides anybody who's a member of those deputy gangs is fired. The banditos I mentioned, the executioners, all the evidence available to the Sheriff's Department is that they don't include a significant number of African American or female members. And as that new law is written, that makes them law enforcement gangs by definition, gangs, not cliques, not secret societies, not anything else, gangs, because they violate that federal law right there by creating a workplace environment in which there's a benefit given to people based on their race or their gender. So we'll investigate those. We'll find out who the members are. We'll find out what the racial breakdown is. And anybody who is a member of one of those gangs, by law, has to be fired. That will not happen as a result of a corrective action plan. The government does not learn from its mistakes in any significant way. In minor ways, yes, it can correct actions that it didn't like, that the government itself thought weren't good. But when the government itself, the leaders, the elected sheriff, the elected anybody, or the deeply entrenched bureaucracy sees a course of action that they're fine with, there is no force on this earth that can allow them to voluntarily change. And that is Frederick Douglass's point. And I believe that Frederick Douglass is correct. It is only voters and courts through consent decrees and public information that can actually result in real change. Confidential corrective action plans will not do it. Thank you very much.
Thank you, Mr. Huntsman. Some very interesting comments. I'm sure there'll be a lot more discussion on those as we move through the rest of this morning. But again, thank you so much for those comments. With that, it brings us to our last panelist to have their own statement. That is Eric Miller from Loyola Law Schools. Mr. Miller, thank you so much for being with us, and please go right ahead.
Thanks very much. Hopefully you can hear me. So an approach to risk and regulation focused on episodic interactions between the police and public that result in large payouts is likely to heavily underestimate the systemic factors that generate the harms resulting from those encounters, and so also the remedial measures necessary to ensure that such injuries don't recur. Well-known disincentives to litigate against the police suggest that an episodic individualized tort model is likely to significantly undercount both individualized and systemic problems in policing. These problems remain hidden in certain socially vulnerable communities, such as people with mental health problems and houseless people, but also communities of color, who are unlikely to receive the attention of the plaintiff's bar. Furthermore, systemic problems addressed through injunctive relief are less likely or unlikely to show up at all in a model that highlights damage awards from individualized tort actions. So the CAP model adopts an essentially reactive policy focused on addressing the risk of future litigation by responding to discrete individuated episodes that are unlikely to capture the more widespread problems of policing identified by, for example, the Office of Inspector General and the Civilian Oversight Commission. So in my remarks that follow, I want to focus a little bit on these structural problems of a risk analysis model that focuses primarily on responses to piecemeal episodic interactions between the sheriff's deputies and the public. For the most part, tort approaches address outcomes of institutional decisions about how to distribute policing among the community and what sorts of policing to distribute. The inputs of institutional decisions about the sorts of policing experienced by the community are mostly obscure. These include, among other things, decisions about training in the academy, the probationary period on patrol, subsequent training in policing that respects the lives and dignity of the people and the communities with whom the deputies interact. Policies about de-escalation, mental health evaluation, the treatment of unhoused people and their property, avoiding racial profiling, and other forms of bias are the sorts of training that I'm talking about. A core problem is the lack of information essential to evaluate the effectiveness of that training and of policing in the field to address the practices that produce the sorts of incidents that result in torts or result in the sort of widespread activity that Inspector General Huntsman's been talking about. Traditionally, policing is a low visibility occupation, and the confidentiality of the corrective action process reinforces that lack of visibility. However, policing has high visibility in those communities where the impact of policing is extended across groups of people and over time, and especially those communities to which policing is distributed in some communities get more policing, other communities get less policing, and that distribution itself is an important part of where policing is likely to lead to harms and injuries and torts. We might think that, given the nature of reporting requirements, certain types of problem, such as automobile accidents, are more likely to reflect the actual number of incidents than claims resulting out of civil rights actions and personal injury. And that's because Where the claims reflect the impact of vulnerable populations with less access to lawyers, then tort litigation is likely to significantly undercount the extent of the problem. Whereas with automobile accidents, with reporting requirements and such, we're likely to get quite an accurate count of the problem. Did I know?
Yeah, Mr. Miller, please continue. For some reason, we seem to have lost your picture, but your audio
Okay.
continues to go on. So please go ahead.
Okay, good. So given these restrictions, the sort of additional information generated by the Civilian Oversight Commission may be valuable here to the extent that we think that it's good at receiving feedback from the various impacted communities, who can then use the Commission oversight process to raise issues surrounding persistent problems and the risks associated with police interactions and the public. However, without the ability to engage in thorough collection and review of evidence and information relating to policing policy and practice, the Commission's ability to evaluate both problems and compliance is limited. So the Commission lacks the legal ability to litigate to enforce failures by the Sheriff's Department to cooperate with requests for information and evidence without the additional cooperation of the Board of Supervisors. But as Mr. Huntsman has so eloquently described, the Board of Supervisors faces structural administrative issues of institutional capture and political pressure that, for example, private insurance regulators do not. And there is some evidence that private insurance regulators have been quite effective in promoting institutional reform among some small police departments in ways that state or county institutions have not. So there's a significant worry that without consideration of the systemic institutional factors, both in the Sheriff's Department, but also in the wider bureaucracy, that produce some of the significant problems regarding, for example, use of force in shooting, criminal misconduct, and violations of civil rights, we're likely to produce only limited procedures to address underlying systemic problems. So all we get when we consider individualized episodic torts are individualized episodic solutions, when what we need are systemic solutions. So instead, what we need is a process that includes not only discrete corrective actions focused on individual officers, but a process that addresses the problems of evidence and accountability. If the Sheriff's Department and the Board of Supervisors are to address some of the more serious, persistent problems facing police interactions with the community. Thanks.
Thank you, Mr. Miller, for your observations. At this point, I want to ask a few questions and see if we can't get a discussion going here amongst the panelists. There will be time for questions and from the public in a few minutes, but first we'd like to ask the panelists a few questions. And I'm going to start off with just a general question to everyone. I mean, how can we do a better job? How could the county do a better job in looking at this whole the problem holistically? I am very clear that, you know, like you say, on these discrete issues, we can do a fairly good job on traffic collisions. But when we have a systemic or systematic problem, we seem to be less effective. I'm wondering from the Inspector General's point of view, from risk management, is there a process by which you take a holistic look at all of these corrective actions and say, we see a bigger problem here other than a few individual deputies or anyone else in the department taking action that's against policy? Is there some Is there a better method that we could use to look at this thing more systemically and holistically? Anyone want to jump off on that? I hope I made the question not too difficult.
Yeah, I'll start with that one. So I would say that the CAP process is a way to identify the issues that cause the actual event. A lot of times you're not looking at an incident occurred, but actually what caused it. If you're not going to do a root cause analysis and you're not going to do a corrective action, you're not going to know what caused the event to occur. So you need to go through, you need to look at it. And in the aviation process, this is actually where corrective action processes started. When planes were going down and we were having issues with that, just culture was created and corrective actions where you'd look at a root cause analysis and say, well, what was the problem? And a lot of time we're very quick to say it was a bad individual, a bad apple. Bad apples are far and few between, believe it or not. Many times the corrective action is a system issue, as you just pointed out. And so you need to look at why did it occur? We've actually seen a reduction in the lawsuits and the claims in the Department of Health Services since the corrective action plan process began. Because they would look at, let's say, something like mislabeling drugs, and we saw, oh, there wasn't one nurse grabbing the wrong bottle. It was all these bottles were labeled the same way. And so we had to change the labeling system. This was department-wide, this was county-wide through all of our different hospitals. So that's an example of a system-wide occurrence that we needed to change the labeling of these drug bottles and not blame the nurse who picked up the wrong drug. So you have to look and identify what's actually causing the problem. Was it the bad nurse? Or was it that all of these pill bottles all were marked in the same way, labeled the same way? And how did we fix it? Blaming that one nurse wouldn't have fixed it through all my other hospitals. I needed to fix that so this didn't happen countywide. So that is when the corrective action plan process does come into play. And so I would disagree that the corrective action plan process isn't relevant on issues like this, because we do look at system issues and we do fix that so we don't have a similar incident occurring a week later, a year later, 2 years later.
Well, I think we can all probably agree that the medical services in the sheriff's department look a little different. I appreciate what you've done with medical services, though. That's incredible that you were able to identify and correct a systemic problem. But I'm wondering from the sheriff's department point of view, and maybe I'm looking at Mr. Huntsman and Mr. Miller on this, how do we deal more openly with what the problems are so we can identify what they are? I'm going to specifically ask this issue of non-disclosure agreements that it appears are routinely entered into at the conclusion of lawsuits. Do you see that as being problematic in that oversight is blocked from knowing exactly what is going on so they can take effective measures to correct the problem?
Well, JP, you're Commissioner Harris. You are correct that oversight, that those confidentiality agreements are an abomination. They're in violation of public policy and they should not be engaged in. And if we had a functioning oversight system, they would be a real problem. But our problem is much deeper. What Destiny says about nurses in a hospital is absolutely true. If the nurses are all trying to save the patients and there's errors, it's more likely that the errors are systemic in a way that everybody can agree needs to be fixed. But that's not what we're dealing with in the sheriff's department. We're dealing with a fair number of bad apples, and possibly bad apples that are so rotten that they floated to the top. And as a result, we have intentional criminal conduct. And how do you deal with that? Well, the answer is it has to be public. And yet here we already are with public information out. Everything I just talked about is, you can Google it and you have it. It's not a secret anymore. It's known to the public. When I was first hired, you mentioned Gloria Melynie, or maybe Commissioner Ocen did, who began in the 80s creating the first Inspector General, and Inspector General with a specific job regarding corrective action plans. When she hired me, she with curse words included, she said, Max, the question isn't what's wrong. We all know what's wrong. You just need to go fix it. And of course, I was new and needed to go find out what was wrong. 7 years later, now I know what's wrong, and she was right. It's on the front page of the paper. What we need to do, and I don't know that the government will ever do this voluntarily, hence the Frederick Douglass quote, is for the county government collectively to stand up to that unlawful behavior. We've had court rulings regarding the transparency laws that have been passed that are routinely violated. We have had front page articles about a secret police unit targeting public officials with threats and intimidation tactics. We've had a whole series of refusals, obstructions of lawful requests for documentation. Forget that there might be a confidential corrective action plan. When Compton alleged fraud, the sheriff blocked our ability to look at the evidence. The Contract Cities Association has requested us to conduct audits. West Hollywood has requested to conduct audits. We can't do it because the sheriff has blocked us. All that has to happen is that the government has to police itself. The DA, the AG, the U.S. Attorney all have direct legal authorities that allow them to control unlawful behavior in the sheriff's department. The county itself has a more limited set, and the board is exploring mechanisms by which they can retool HR to have the ability to force lawful action. Because before, the premise had always been, if you simply make the law clear, the people violating will do it correctly. It fits in Destiny's example. If I'm a nurse, I want people to live. So if you correctly label the bottle, I'm going to use the right one. But that's not what's happening in the sheriff's department. What we're dealing with is a cultural and political insurgency, an effort to change what the laws are, to make the sheriff above the law so that a group of people who feel underrepresented can do as they wish. And that's not democracy. It's not lawful. And the response the county has to be a legal one.
If I can jump in as well.
Yeah, please, Mr. Miller.
So I think it's important, and again, this is one way of trying to respond to the example of the difference between healthcare and the sheriff's department. I think it's important, in part because the sheriff himself emphasizes it. The sheriff has an important political position that isn't quite the same as a medical professional, and so as an elected county official, the sheriff is responding to a whole different set of incentives than medical professionals. But I think it goes beyond that, and so understanding the institution of the police in general and the LA Sheriff's Department in particular is really important and incredibly complicated. And so the range of incentives that work in the Sheriff's Department strike me as deeply complicated. Traditionally, standard way of thinking about police departments has been in terms of conflicts between management and street police, in which street police generally resist oversight and develop their own practices and policies that govern interactions with the public. Where management operates sometimes in response to demands for increased oversight by trying to regulate street cops, and sometimes in response to demand for increased oversight by retrenching and engaging in, as it were, solidarity with street cops and preventing external oversight. And so the question then becomes how you can force, when we're in a retrenchment period, and I think we're in that sort of period now, how you can enforce oversight. And again, there are, as Inspector General Huntsman pointed out, severe conflicts of interest between, as it were, the investigators and evidence gatherers, and then the prosecutors who use investigation and evidence as part of their job to prosecute. And so that in part explains why the DA and the federal government has been somewhat reluctant to act on clear signals of problems with at least certain groups within the Sheriff's Department. So, for example, the sheriff gangs that Inspector General Huntsman has identified. And then, so the question is, what sort of oversight group can do its job when the sheriff refuses to be responsive and asserts his political independence from doing that? And it has to be, one answer is a democratic process. You just elect, he just gets unelected at the end of his 4-year term. But that can't just be it. There has to be some kind of attempt to use either litigation, but also the Board of Supervisors has the power of the purse as well. And so even though the sheriff gets to determine how money gets spent, there are ways to restrict the amount of money that goes to the sheriff as a way of, so to divert money to other groups that perform many of the functions that the police do. So mental health, policing can be done, for example, by social work groups. And I think that threat is a real and genuine one. And it's worth considering systemically whether a group that focuses primarily on deploying force ought to be tasked with doing these other functions. And to the extent that the sheriff refuses to comply with some of the mandates of oversight, there are ways in which, why isn't the Board of Supervisors litigating to force the sheriff to turn up to meetings and to provide documents requested under subpoena?
Thank you. And all exceedingly good questions that I'm sure I would love to know an answer to as a commissioner, and I'm sure other commissioners would be interested also. I know I'll only speak for myself, but I am massively frustrated by our lack of ability to obtain information from the department. If it wasn't for the Los Angeles Times and other media sources, sometimes I wonder if we'd know at all what's going on in the Sheriff's Department. And that's a real frustration, and it doesn't need to be that way, and it shouldn't be that way. Anyone else? I don't want to cut out the sheriff's ability to react on this if they feel inclined to want to do so, but I'm not gonna push your arm to do it either. Anyone else have any comment on any of this?
Yes, good morning. Thank you again. I just want to say real quick, working here in risk management for about 2 years now, I will say that the corrective action plan and a summary corrective action plan is very effective. It's an effective process for the Sheriff Department. It allows our flexibility to identify root causes and make changes and policy changes and countywide training and education for our department employees. I will also like to give an example of an informal corrective action plan, and that's why it's very effective in all degrees, formally on a formal document, but also in-house. In-house informal corrective actions is very important for the Sheriff Department as well. Let me give you an example. We have a reoccurring problem or issue such as poor radio transmissions in certain areas. Well, we were getting complaints. Things would happen where deputies will call for assistance or backups to de-escalate a situation or call for assistance to handle incidents and so forth. And the radio transmission was very poor. The department took a look at our radios and they actually corrected the problem by being proactive, by replacing repeaters throughout the county, as well as upgrading department radios. So I will say that an informal corrective action can be effective as well as a formal corrective action. So in my opinion, for the 2 years and for the 25 years I've been working for the department, I will say that a corrective action is very beneficial and important to the sheriff department as well as effective. Thank you.
Thank you. Thank you very much. I think at this point, let's go ahead and open this up to questions from the public. Jennifer or whoever is monitoring this, do you want to make the announcement regarding how to submit a question?
Absolutely. So if you are logged on to the WebEx, that is the only way that you can ask a live question. Please go to the participant window, and in the bottom right-hand corner, you'll see a small hand that you can raise. Click to raise your hand. When it is shaded in gray, that means your hand is raised. If you have any questions, please send a chat to the host, and we will make sure that you're in queue to ask your question. And with that, we'll go ahead and take the first question. And just a reminder, these are not timed because these are not public comments. These are specifically questions for the commissioners. So please keep that in mind. Christina Vasquez is our first question. Christina, you are unmuted. Please go ahead with your question.
Hi, yes, good morning. I have a few questions. Being an impacted family, my husband was killed by the Pico Sheriff's Department October 6th of 2019. And seeing the slideshows, it all looks great and wonderful, and it sounds very promising. And if I was in an impacted family, I would be thinking, well, they have a really good system and it looks like it's really working. But seeing as how it's been 2 years and our case still has not been investigated, they haven't closed it. Well, I heard that they closed it, but the investigation hasn't been complete. Our attorneys had to put pressure on the district attorney's office to have my husband's case completed, the investigation completed by his 2-year anniversary, and they still didn't do it. My question for you guys was, what is the amount of cases coming in? Because the graph shows like you guys are getting a lot of things done, but what's the amount of cases coming in and going out? What's the turnaround time? What's the line of accountability in regards to a time frame? And I know the last woman who just spoke talking about replacing the radios in the patrol cars because people weren't coming on time to show up to de-escalate a situation. Has there been any talk of implementing the use of body cams for the sheriff's department? I know that it's standard for LAPD, but what about the sheriff's department? Why is it that they've had the option to not use body cams? Because as far as I know, the case in shootings has been very high and the use of body cams has been very low. Sorry, I know that's a lot of questions, but that's what I have.
Well, thank you. I'm just wondering, maybe Max can answer some of those, specific to the body camera.
Yeah, I can do the body camera piece. That's correct. There is a policy at the Sheriff's Department that allows spotty use of body cameras. It was an issue we raised when they were implemented. The department, we pointed out the language that was ambiguous. The department assured us that it didn't mean what it seemed to mean. It actually meant turn them on all the time. And we've now found, as we're watching them in progress, people who have body cameras assigned often don't turn them on because of the ambiguous policy, at least in part. Part of it, I think, is also the problem that Destiny Castro described of, when people want to do a thing, they still take some time to learn how to do it properly. So I think there's some growing pains, but we've seen, I think, too many to think that it isn't also a problem with the policy, which we flagged in the beginning. And that gets back to the point that Professor Miller has made of the difference between a minor technical issue that you can correct by simply pointing it out and more systemic problems that are baked into the way in which individuals want to do their job rather than the way in which they're legally obligated to do their job. As to the other issues regarding volume of lawsuits, I'd leave that to the other panelists, although I would say you got to keep in mind that the speed by which a litigation is completed is completely outside the hands of the folks you have here. that's in the hands of county council and the plaintiffs. So if you have a lawsuit, then your lawyer gets to decide how quickly it goes, and their lawyer gets to decide, not in a vacuum. It's kind of a process. And some lawsuits go very quickly, and there's a settlement really quickly, and other lawsuits go to trial and takes years. And, you know, there's a wide variation, and no corrective action plan of the sort that you heard described earlier is created until the end of litigation. As I say, I would argue that the litigation process hardens the positions of the parties, so that when government has spent all its time trying to convince a judge that you are wrong, that when they then sit down to write a corrective action plan, it sometimes isn't what it could be. But that delay that happens during litigation has nothing to do with the process you've just heard.
Okay.
Anyone else want to weigh in on that? I know she did raise the issue of the fact that cases seem to languish in an open status, or even once the department has said we're done with it, they seem to languish over in another county department. That would be the district attorney. I don't know if there's anything this group can do about that, but I know that is a historic problem.
Yeah, let me talk about that. The district
Right.
attorney has nothing to do with this, because that's criminal prosecution. We're talking about civil lawsuits to trigger corrective action plans, and they operate on an entirely separate schedule. There are times that criminal cases can stop civil cases, but that's unusual. Secondarily, there's also an impact on criminal cases on internal cases, but again, that's voluntary on the part of the sheriff's department. They choose to wait to do their IA cases until after criminal cases are done. So is there a problem with the DA's office taking too long? Yes, but does it then cause a delay in corrective action plans in civil cases, or say prevent the firing of somebody like, I won't give examples, specific examples, but an instant where the sheriff has ample evidence of misconduct that they could take immediate corrective action? No.
Okay, thank you.
Well, I'm just going to weigh in on that one too, Mr. Huntsman. I'm not sure that, well, we may have a disagreement there, because it seems that the department really doesn't have the ability to take effective corrective action until a potential criminal investigation is totally completed. And since that can take years and years and years, it could take the department that same amount of time before they are given the opportunity to effectively deal with the potential administrative violations that led up to a, or part and parcel of a criminal violation. So it would seem that I know the rules between the sheriff's department and the rules that govern the LAPD are very different in that regard, and that LAPD can run a parallel administrative investigation at the same time they're doing a parallel criminal investigation, where the sheriff's department is blocking doing that.
The sheriff's department can as well. That's the mistake you're making. It is
Okay.
the case that there is a case that was a negotiated agreement between the sheriff's department and the union, that they could not conduct an interview of a target in an internal affairs investigation during a pendency of a criminal case against them. That is the extent of the agreement that they agreed to and have never renegotiated. So one, they should renegotiate it because it's inappropriate. As you point out, LAPD has a different model that works just fine. But even under that legal restriction, they are in no way prevented from conducting an internal affairs investigation during a pending criminal case. And in fact, recently, the sheriff's department conducted a process whereby they concluded they ought to have fired somebody who conducted a shooting long ago, which is still sitting over at the DA's office, in which the day it happened, I think a lot of people looked at the evidence and said this person should be fired. Maybe some people thought they shouldn't, but there were certainly people who thought that was a possible outcome. And eventually they moved forward with the evidence they had available to them, and that doesn't include a forced interview of the target. But sometimes you have plenty of evidence independent of that. And just like with a criminal defendant, you often don't get to have a confession in order to do a prosecution. So the sheriff's department is absolutely legally and procedurally entitled to conduct internal affairs investigations during criminal cases. They choose not to.
And it looks like Commissioner Harris, you're muted right now.
Thank you for that clarification. That is also something that I've noted myself, that you don't always have to have a subject interview to move forward, but we seem to make that the reason why we can't move forward virtually in every instance. Do I have another question from the public?
Yes, and next we will hear from Sonia Ramirez. Sonia, you're unmuted. Please go ahead.
Morning, can you hear me?
Yes.
Okay. First, I just want to say thank you to the commission and to everyone, the panelists. This is so informative for us as a community to know kind of what's going on. But so my question is for the sergeant. This is really informative, but me as a member of the community, I was wondering, where can I or anyone else in the public see a record of previous corrective actions? And how far back do those records go? How accessible are they? Also, is that on a site, or is that something that we have to ask for? I guess my question is based on just how is the department making sure that it stays transparent to the residents?
Thank you, Ms. Ramirez, for asking that question. It's a great question. You can actually find the summary corrective action plans on the Board of Supervisors website. If you follow the case name, if you know the case name, click on the attachment and the summary corrective action plan is available for you to view. As well as if you have concerns and opinions about the Sheriff's Department, you can also reach out to your district Board of Supervisors representative. Or do you live in the county in one of the county areas that we service?
Yes.
Okay. You also have the option, ma'am, is to maybe go down to the station, have a meet and greet. I know at patrol stations, working over 11 years in patrol, that they have town hall meetings. I would advise you to maybe go to a town hall meeting, have those conversations with the captain or lieutenants and sergeants. I think that would also build that community trust and transparency with the Sheriff Department as well. And thank you for your question.
Oh, I have a follow-up. So how far back do the records go? Like if it's from maybe a few years ago, can I still access that on the site?
That is correct. I'm sorry.
Sorry, this is two. And how quickly are those corrective action plans posted on your site?
They're not posted on the Sheriff Department website. They are on the Board of Supervisors website. If you can follow the case name, you will be able to find the summary corrective action plan. If you contact the Board of Supervisors representative, you're in your district, ma'am, they will be able to educate you on how long a case connected with the summary corrective action plan is available to the public on their website. Thank you.
Okay, thanks.
Thank you, Sergeant Rivers, for that answer. Jennifer, do we have another question?
Yep, we will move on now to Melissa Camacho Chung. You're unmuted. Please go ahead.
Thank you very much. I'm a staff attorney with the ACLU of Southern California, and I have a question. I understand that there needs to be litigation for the corrective action plan to be triggered, but is it possible for the Board of Supervisors to request a corrective action plan if there is an incident that they want, I guess, a plan developed for, but that no litigation was actually instigated?
I'll take that one. Absolutely. So the board can request a corrective action and investigation at any point in time that they feel is necessary. My job and my title codified under the county code, I can also do the same thing. So sometimes if there's an adverse jury verdict or we see an incident that we believe needs to be investigated, the board and myself have the authority to do that. And we do that when requested, and if we see something that needs to be looked into, and then we can request a formal corrective action plan that the department will need to be responsive to and provide within the 90 business days. Just like over 100,000. Thank you. That was a good question.
Thank you very much.
Thank you for the question.
And next we will hear from Julie Martinez. Julie, you're unmuted. Please go ahead.
Hello, this is a question about corrective action, but I wanted to frame this with when we see that the Villanueva, there's overwhelming evidence that Villanueva's career was developed under a department with a historical continuation of criminal behavior. I'm not saying that you're guilty because your career developed under corruption. However, his actions from day one to defy the rule of law, one very basic rehiring of Mandoyan, who was guilty of domestic violence. Villanueva's several comments about taking the 5 women board of supervisors to the back of the shed for a beating. Villanueva's ignoring the community when we stated that deputy gangs ruled and ran stations. And then when whistleblowers showed up and the Kennedy Hall incident occurred, then in addition, Villanueva removed oversight at disciplinary cases. Under Villanueva, community members who complained were very often targeted by harassment from sheriffs. So the head sheriff, who's mandated to fulfill the mandates of the law, is really the sheriff of lawlessness. He refused to follow California Law 1421, which allowed transparency. The list goes on, and obviously the last and most egregious is a secret police style investigative unit that goes after his personal enemies, including you, the COC and the BOS. So my question is, when the institution itself is so corrupt, how can we as a community have any faith or belief that there would ever be correction action? And I have to add this too, because there was an incident with my family that we did file a complaint, and a few days later, past 9:30 p.m., someone knocked on the door, and it turned out after the family was already in their pajamas, everyone's going to bed on a school night, someone from the sheriff department, this is East LA Sheriff, yelled through the door that they were here to follow up on a complaint style process, and they asked to come back. When they went to follow up to find out what happened to this complaint, they were told that the community member refused to respond. So I guess my question is, there's so much entanglement of lawlessness in this department, including asking for a basic complaint process to be fulfilled. How do we in the community even trust the sheriff department to take any form of corrective action when they don't take the basic first steps?
Well, I don't know if anybody wants to jump in on that one. That was an awful lot of meat there. Anyone want to tackle that?
I'll jump in. I think one of the things that's really difficult in the police complaint process is whether the police have, and this sort of ties into some of Inspector General Huntsman's comments on bureaucracy more generally, have an interest in following up on complaints against them or not. In other words, the worry is that when you're complaining against the police, there's sort of less an incentive. Like, it's not like you're posting something on Yelp that says don't go to this business. The police are sort of aren't that kind of service. So that's one way of just thinking about it, is that in general there are institutional problems with the complaint process, and so should there be an independent ombudsman that does the complaint process that would be more responsive to civilian needs? I think that that's certainly something that is worth considering, but that goes in some ways beyond the scope of the current discussion. What it does suggest is, as we've been saying, the complaints process, even the torts complaints process, I've been suggesting is broken because it doesn't address vulnerable. There's different types of complaint and corrective action, and the instance of an automobile accident is very different from the instance of vulnerable communities coming to the police to complain about actions that have been taken against them as part of policing, and finding and empowering those communities is itself part of the problem that especially a tort process overlooks, but also just the general complaint process overlooks. So I haven't addressed your worry of lawlessness, but certainly if the institutions, if the sheriff decides not to be accountable and just to ignore complaints, then absent some way of forcing the sheriff to respond, there's not much that can be done. And that strikes me as a really problematic aspect of the current posture, especially the posture of the Board of Supervisors towards the sheriff, because it strikes me that at a variety of levels, the district attorney, the Board of Supervisors can all in different ways call the sheriff to account. It is just often politically, it creates political problems for those institutions if they were to go up against the sheriff.
Thank you, Mr. Miller. And Jennifer, if you could reach out to the woman who just made the last, provided the last question, and I'd like to have staff get some information on that particular complaint, the allegation that someone went out to the house late at night and that the complaint was ultimately closed because there was no one responded to their questions. If we could follow up on that by staff, I would really appreciate that. And do we have another question?
Yes, we will follow up with you, Julie. And the next question comes from FC. You're unmuted. Please go ahead, FC.
Hi there. So I have two questions actually. I hope that both can be answered. The first one is, how can the public know, or how does the department know that these corrective actions are sufficient and that they're being implemented properly? Especially because some of these things take time to be implemented. How can we be reassured about that? And my second question is about LASD's Risk Management Bureau. I think that you said that there are some informal or non-formal corrective actions. If so, how are those prioritized, and are they tracked? And how can I guess the public know more about those? Thank you.
Sergeant Rivers, you want to at least attack the second question?
Yes, thank you. Thank you for that question, FC. For informal corrective actions, those are informal and handled through the Sheriff's Department. That is not public accessible. So informal corrective actions is a department handle. So it's not available for the public as an informal corrective action. And as for how does the public would know if a corrective action has been implemented is once a corrective action from risk management is approved by the Board of Supervisors, as well as during the process of a corrective action, risk management actually relies on the concerned division to ensure that the corrective actions that were recommended are implemented at their bureau or unit or station. As for the public's knowledge of that corrective action being implemented, you automatically see that by our actions. You will see that through policy changes. As you can see, we have body cams that the sheriff has implemented. So you will see those types of changes, but you will not necessarily know exactly when that concerned division has actually implemented the corrective action, because it's a process that they do continuously. Thank you for your question.
And I think we're going to have to wrap this up in the interest of time. We're going to go a little bit over, it looks like. But I would just like to thank all the panelists for sharing your insights with us and the community today. And I want to thank the community for tuning in. I think we all see that these questions, sometimes they spin off into a lot of different areas that may not be directly on topic for the particular panel, but they all interrelate with one another. But I really appreciate everyone taking the time to come here and share their knowledge and insights about the Sheriff's Department. And with that, I think this this operation is completed. Thank you so much.
Thank you.